Three, two, one. This is the Phantom of Many Topics. Today is May 3rd, 2022. Yesterday evening, Politico announced that they had gotten a copy, perhaps from a law clerk or somebody else. It was definitely a leak of a preliminary decision by the Supreme Court to overturn Roe v. Wade. In it, it was 98-page document. In it, Justice Alito says that Roe v. Wade was basically built on a sandcastle and that it is bad law and should be overturned. So we're going to discuss Roe v. Wade today. I know I generally talk about sports or travel or whatever, but I think it's important for most people to understand why Roe v. Wade was very bad law and was a bunch of left-wing judges basically doing what they couldn't do through the legislature, so they decided to do it through the courts. And that's not the way our law should be, especially not at the Supreme Court level. Okay, I know that some people are pro-choice or pro-life. I myself, I'm actually pro-choice. If I were a House rep or a senator or a state rep or anything that had to do with the legislature, I would be trying to pass a constitutional amendment to try to guarantee the women to have the right of abortion on demand, at least for the first trimester. Okay, I'll say that much. However, when you are a judge or a justice, you're supposed to be a referee in the situation. And because I'm a soccer fan, I'll put it this way, okay? If I'm a referee and I like Chelsea and they're playing Manchester United, I can't just decide to make up rules that would favor Chelsea. I'd have to be fair and judicious about it. And the 1973 ruling, even according to Justice Ginsburg, she said that that was really just bad law, even though she supports the cause. So I'm going to explain to you why the 1973 ruling is wrong, and that's topic number one. Okay, so topic number one is the 10th Amendment. The 10th Amendment says that anything not mentioned in the Constitution is automatically turned over to the states for a decision. And neither the word privacy nor the word abortion is in the Constitution. So therefore, you can't say that it's a constitutional issue at all. Okay, even though it's sensitive to women, and the women's rights activists will go like, well, men shouldn't be able to control women's bodies, blah blah blah. That's not law. Okay, in the Anita Hill hearing against Clarence Thomas, one of the conservative senators asked them, well, what should be the standard to define sexual harassment? And then someone else answered, well, it should be whatever the women decide it is. Well, that's not law. Okay, so we cannot have laws that are based upon just, because it's a bunch of men deciding for women or a bunch of women deciding for men. Let's say if we had a draft and only men are subject to the draft and women are not, then if a woman judge says that we should have a draft, then, So anyways, I don't want to get sidetracked, sorry. But I just want to say that the 10th Amendment is the controlling controlling legal principle here, because the 10th Amendment says if it's not in the Constitution, then you have to give it to the states. So therefore, I'm going to say it insensitively, but the topic of abortion is no different than casino gambling, okay? Casino gambling is not mentioned in the Constitution. Therefore, it reverts back to the states. Each individual state gets to decide whether or not abortion should be legal. This is until such a time that you decide to pass an actual amendment to the Constitution guaranteeing the women the right to choose. And we'll get into that as topic number 4. But right now we're only on topic number 1. Okay, stare decisis. Stare decisis is the liberal argument of why Roe v. Wade should not be overturned, even though it was created on bad law. And that's wrong. Okay, they go like, well, it's been 49 years since Roe v. Wade was ruled, and that's been such a long time that it's been ingrained into our society. But bad law is bad law, and bad law should be overturned immediately. I'm surprised it has taken 49 years for this bad law to be overturned. The Plessy versus Ferguson was the law that was a racist law that allowed segregation to be, separate but equal. So as long as you had an equal drinking fountain, then you can have a white drinking fountain and a black drinking fountain, or white bathroom, black bathroom, blah, blah, blah. That lasted for 53 years, and it was overturned by Brown versus the Board of Education. Okay, so stare decisis means nothing when you have bad law. And that's what Roe v. Wade is. It's bad law. It's bad law for several reasons. Because first of all, it has nothing to do with the 14th Amendment, which was the flimsy reason why the liberal justices said that it could be, it should be legalized across the 50 states. Also, the litigant, which was Roe, her real name is Norma McKevey or something like that. Okay. She already had the baby, later known as Shelley Thornton, by the time that Roe v. Wade went through the courts. So she doesn't even have standing to sue because she's no longer in the situation of even being pregnant. So the fact that alone should have been the reason to throw Roe v. Wade out of court, but they did. The liberal justices, again, they couldn't get enough votes in the legislature to get the pro-choice amendment passed, so they decided to just try to get it through the courts. And when you try to get something like that through the courts, and that's going to be topic number 3, judicial activism versus plain text law. Okay, it's like cheating and building a structure on the beach out of sand. Okay, it's like building a sandcastle, because you use judicial activism to get your way because you couldn't get enough votes in the Congress to pass the law, to pass the amendment for the, it requires two-thirds of Congress. And then it also requires 3/4 of all the state legislators. And so that's basically a supermajority. And if you don't have a supermajority, then you don't have an amendment. And if you don't have an amendment, then again, going back to the 10th Amendment, each state gets to decide for itself. And again, whether you like it or not, abortion is no different than casino gambling. Okay, each state gets to decide for itself. That's how the Constitution was set up. Now, you can say that the Constitution was set up by only property-owning white men. It doesn't matter, but that is the basis of our law, and it is what it is. Okay, plain text laws, again, that's pretty easy to read. 10th Amendment says, guess what? If it's not in the Constitution, and neither the word abortion nor privacy is in the Constitution, it reverts back to the states. So only things that are mentioned in the Constitution are constitutional issues. And when the liberal side says that this is a constitutional right, it is not a constitutional right. It was a court interpreted right, and it was a badly interpreted right because, again, those justices at the time in 1973 were all appointed by LBJ and JFK, and they were just trying to push the liberal agenda. And as a referee, I would be disgusted. And that's what judges are. They're supposed to be referees. Judges do not have the right to make law. They're only supposed to interpret the law. Okay, they're only supposed to interpret the law, not make the law. And so now we get back to topic number 4. Topic number 4 is pass an actual amendment. Okay, if you have such a supermajority, you said, oh, okay, so liberals are saying that they have 60% of America. Well, it requires 3/4 of the state legislatures. That's 75% of America. 75% of American states need to agree to this in order for it to be a pro-choice amendment. And actually, I didn't create a banner for topic number 5, but I'm going to say this. The overturning of Roe v. Wade does not make abortion illegal. Again, it's just like casino gambling. Each state gets to decide for itself. So if you have a woman, put her on a bus. I'm sorry. Put her on a bus to New York, California, or your neighboring state. If Texas doesn't have it and New Mexico has it, or if Utah doesn't have it, then you put her on a bus to Nevada. Sorry, but that's the way the law works. There is no law until there is a law. And in 1973, the liberal justices made a huge mistake. Now you can say, oh, well, poor women would be affected by this. Well, start a charity or start, one of those financial charity causes. Have Bill Gates. He's always going around to Africa, doing the vaccination charity. Have one, start one for abortion rights, if for abortions. So that way you take care of the Greyhound ticket fee to travel from Salt Lake City to Wendover, Nevada. Sorry, I'm being insensitive. However, law is law, okay? It doesn't matter whether white men or black men or black women, or it doesn't matter. The law is, you ever heard of this term? Justice is blind. Justice is blind. Okay, so basically that's that. This has been an injustice that I felt all my life, that Roe v. Wade has been incorrectly ruled. It makes a mockery of the law. It has made a mockery of the law for now almost 50 years, and it needs to be overturned, just like Plessy versus Ferguson was overturned by the Brown versus the Board of Education. Segregation is wrong, and it was overturned. This abortion decision in 1973 was wrong because it's not constitutional. I'm sorry. You can make it constitutional, but again, you have to go through the process of adding an amendment to the Constitution. You can't just decide on a 7-2 ruling at the time in 1973 with your liberal justices that it is constitutional, because then 49 years later, when the conservatives have enough justices to decide that you were wrong, then they can just overturn it. And then maybe in a few years, the conservative justices died, and then it ping pongs over back in your direction again, and this is never going to end. So in order for it to end, you need to pass a constitutional amendment, okay? Let's go back to topic 4. You need to pass a constitutional amendment. Otherwise, you're just building sandcastles on the beach, and when the tide is turned, your side is just going to have your law washed away again. And again, I'm not going to go into other topics such as presidential overreach, the expansion of executive orders, and so forth. But again, this is something that should be handled by the state legislatures and Congress. If you want to pass a constitutional amendment, you need to go and do it. Okay? If there's not enough people in America to get the supermajority, again, you need 2/3 in the House and the Senate, plus 3/4 of all state legislatures. Then it doesn't go into the Constitution. That's the rules. That's how it is. It's like in a soccer match. If you have injuries, you get stoppage time at the end. It's plain cut. It's plain text. Okay. Sorry, women. I'm being insensitive, but the law is the law, and the law is blind. Okay. The law is blind. Okay. Thank you very much. If you like, hit like and subscribe. If you don't like, hit like and subscribe anyway. Thank you very much, and the broadcast.